water in front of you. So my name is Andre, and I'm just going to do a few housekeeping things for everyone just to see where we're at. I'm seeing people here we've seen on protests, carrying coffins, putting out shoes, going to meetings, representing families in so many different ways through your campaigns and collectively. And it's terrific that we can all come together to have a conversation about where we're at now post the general election with a new Labour administration who promised repeal means repeal in terms of the Legacy Act. And it's great that you've given up your Saturday morning to come here together and to do that with our colleagues in Relatives for Justice and the Pat Finucane Centre. And no better place to do it than in this beautiful setting of St Comgall's. And we want to thank Falls Council for being so generous with this space and with all of the facilities that are here today. Just a couple of things. Don't forget about your mobile phones. Maybe put them on silent if you have them there. It's always that thing where you go, flip, I hope it's not me, because it's usually me. The toilets are over here, and there's double doors there. There's a disability toilet, and there's plenty of ladies and gents toilets just here as well. So there is. We're going to get a little bit of lunch when we finish up in and around 12:30, 1:45, and that's going to be served out there. And I want to say that all of these gatherings and when we come together raises very painful and difficult issues for us all. And I want to say that we obviously pay attention to that. We want to make sure this is a safe space for everybody. We want to say that tonight and in the week ahead, you may have feelings that are resurrected by today, and that's absolutely fine. It's absolutely understandable. And we have a couple of people, all of our staff from both our organisations who you know and trust, but also in particular, where's Jim? If he puts his hand up, there's Jim McGivern, and Christina beside her, looking beautiful in her beautiful leopard skin this morning. So if you're feeling a little bit overwhelmed or you feel you'd like to talk to someone, please don't hesitate. It's absolutely fine and safe to do that. And we've little spaces as well where we can have private conversations too. So without any further ado, what we're going to do is introduce Mark and Paul from RFJ and PFC. Then we're going to have families speaking to us about how they feel about the Legacy Act. Then we're going to have an analysis about the recent Court of Appeal ruling that was in the news no later than last night. And then we're going to open the floor to everyone. So everyone's going to have a say, everyone's going to be able to ask questions, have a think about things. No one needs to have a position. People can ask questions and say, I'm not sure, and that's absolutely safe and fine to do in this place. And we will do it together. And by the end, then we'll all have a lovely lunch together. Thank you very much.
Gormila, Andre, it's great, as you say, to see so many families here and reconnecting with people as they come into the room and re-establishing some old acquaintances. So it's great that we're all here. I think it's the first gathering, Paul, that we've had in this sense since the kind of legacy bill's been passed, and we've had the kind of initial court challenge and the Court of Appeal ruling, which have been hugely, hugely significant. What I'm going to do is just take a few moments to run through, rehearse some of the old arguments, thrash a bit out, and give a wee bit of thinking about our views in the ICRIR. Because I know families are talking privately, they're asking ourselves in PFC, they're asking CAJ, Amnesty, and just to kind of note as well, the NGOs, which are a collective of the Pat Finucane Centre, Amnesty International, Rights Security International, and the Committee on the Administration of Justice and Relatives for Justice are collaborating around this work and working essentially with the Model Bill team, which is academics from Queen's University and CAJ that have did sterling work in bringing forward kind of parallel model legislation, highlighting where the British government have failed to meet human rights obligations, pointing out the right direction to go in. Of course, all that's been ignored, but it's a sterling piece of work, and that collaboration, I think, is paying off. It's also important to say there are other organisations like Time for Truth involved in that very public way, giving families the kind of space to ventilate in, whether it's at the courts, whether it's in demonstrations or marches. That collective and all the families and campaigns coming together has had a modicum of success, and it has put it up to the people that want to close down justice. So I kind of just want to run through some of the legacy bill. It is an immunity impunity. It equates to amnesty. There's concerns have been raised by European Commissioner for Human Rights. The concerns have been raised by the Committee of Ministers to the Council of Europe that supervises the UK in terms of its response to the judgments out of the Article 2 cases. And I want to note there are people in the room that have been affected or who were involved in the vanguard and the spearheading the legal challenges around, and particularly in West Belfast here. It's lovely to see Teresa Jordan, who was at the forefront along with her late husband Hugh, who battled that case and continues to, and some of the Loughgall families as well. So it's important to recognise that. They were in that vanguard of cases, the significant judgment in May 2001 with Madden Finnegan solicitors. There's UN experts have said it's a flagrant violation of international human rights standards. The Oireachtas Committee on the Implementation of the Good Friday Agreement have said that the Legacy Act undermines the Good Friday Agreement, victims' rights, rule of law, and due process. And that's important. The Irish government have lodged the interstate case as a consequence, which I think gives you the gravity of what the situation where the British went to in terms of the rights of victims and undermining them. And it's important to recognise as well there are representatives of the Irish government in the room today, and that's brilliant to see. The CAJ and the Pat Finnegan Centre did a report of the International Expert Panel, which was a significant report, Bitter Legacy, and that they said that the practice of impunity was systemic in this society. That's an international panel of experts, highly renowned, highly respected, highly regarded international players on this issue. And then we've had the Court of Appeal, and later on, Professor Colin Murray will give the analysis of that. And all the parties, it's important to say, all the political parties on the island opposed this Legacy Bill, Legacy Act, as did, importantly, all the families. So I want to kind of give a wee sense of the tactic when the British brought in the command paper through to the bill, through to the act, to the May 1st deadline, and many of us were together in the courts supporting families out on the streets campaigning. Many of us affected by the impact of this. They were running down the clock to May 1st. That's what they were doing until this came in. Just to give you an example just of what they're saying themselves about a previous Secretary of State.
I asked in relation to legacy inquests that are currently underway in Northern Ireland, is the Noble Lord the Minister not extremely perturbed, indeed embarrassed by the fact that state bodies appear to be openly running down the clock to May the 1st, when the due process that we set such store by in the United Kingdom will no longer apply in Northern Ireland thanks to the shameful Legacy Act. In one case, a Ministry of Defence official told an inquest that, and I quote, "We have only a single officer supporting Northern Ireland inquests." And in another, the legal representative of the PSNI admitted that further resources could be deployed and more progress made, but said in terms, what's the point? Is this not a disgraceful way to treat victims of the Troubles who've suffered so much already?
Now, I probably should have given you a health warning before showing that video when they talk about the store they put in the rule of law. Obviously, for us, that's a different story here on this island. But nonetheless, a significant player around this issue at the House of Lords opposed this act, pointing out to his own government, this is what you are doing. It's not just us saying this, the international community in their own parliament, that's what they're saying as well. So, the Legacy Act, it cannot work. And it cannot work for a number of reasons. The Legacy Act provides sweeping powers to a British Secretary of State. These powers go way beyond the use of public interest immunity certificates, otherwise known as gagging orders, and this national security, clauses that they use, and they neither confirm nor deny policy, which isn't a law, it's a policy, and that was thrashed out in the case of Paul Thompson. And I know that the Cuskers are here, and in the Brown case, it's relevant to all of those inquests that didn't complete. So, those powers, the Secretary of State were criticised in the Court of Appeal ruling. So the Legacy Act and the creation of the ICRIR, it has a head of investigations who's a former RUC and PSNI Assistant Chief Constable. It's a clear conflict of interest. The ICRIR will not investigate. It will mostly conduct desktop reviews. And Paul will outline later just a little bit about the types of investigation or non-investigation. Families will not be legally represented. So what you go to court with your lawyers, supported by NGOs, you seek discovery and disclosure, you interrogate evidence, you interrogate witnesses, all that's over. That ain't going to happen. That's not the route after May 1st. So this is really what they're doing. What they do is largely conducted in secret. So, you know, secrecy and state cover-up. So it cannot, for example, the ICRIR, if it finds anything out untoward or whatever, if it were to, and I don't believe it can, what it would do is it would have to ask the permission of a British Secretary of State. Can we put that into a report? Can we put that in the public domain? Can we give that to a family? Now, under security, a Secretary of State will ultimately go to MI5, and MI5 will determine what he or she can and cannot do. So we're asking the people responsible for the architecture of state violence and collusion, will they open the books and hand out what they're involved in? It ain't going to happen in this process. That's why it's been designed this way. To give you an example, and again, Paul will touch on this, had the ICRIR been in place quite a number of years ago, you wouldn't have had the information that we have in the public domain around a number of key cases. You know, ombudsman's reports, inquest findings, and particularly, and Paul will talk about this, the information that emerged in open court around the intelligence around the murder of Sean Brown. All of that, we wouldn't know any of it. Wouldn't be in the public domain. And there's no oversight, and there is no way of holding the account, the ICRIR. There's no mechanism to hold it to account. So the architect of the RCIR, one of its key principal people driving it through the British Parliament, the House of Lords and Westminster, was a former person who was at the heart of the NIO and had worked alongside around, we estimate around 5 to 6 secretaries of state in the background, and would have liaised with British intelligence as well as part of all the architecture of this. Let's have a look when he was pressed about what he actually said on TV.
However, the government says the NCND policy on protecting state agents is fundamental to national security. Do you agree with the Chief Constable's comments?
John is entitled to his view on this because he is. The Secretary of State respectfully disagrees with his position on NCND. This is now before the courts, and we have to wait the court's judgment.
But surely in relation to the line, nobody who commits murder should be protected by the policy of NCND.
As I said, I'm not going to say anything which might have any bearing on the ongoing legal proceedings.
Are you confident that killers aren't being protected?
That is really not a matter on which I can comment. That's really the security of that company.
The government is put.
So there you have it. The architect, the proponent of the Legacy Act, when pressed by the BBC, won't say that the British government will not protect killers or state agents. That's ultimately what this process is about. That's why the British government have brought about the ICRIR and the Legacy Act, to protect themselves and protect their agents. That's from the horse's mouth. Batting it off the security matter, he was in that security apparatus as part of the NIO for around a decade. So another instance of why they don't want to go to that place and what it is they're actually protecting. John Stevens did 3 inquiries over 14 years into collusion. It's one of the biggest police investigations in policing history. The only investigation that surpassed it was the 7/7 attacks in London. And this is what he had to say about his findings.
MI5, the army, doing different things. And when you talk about intelligence, of the 210 people we arrested, only 3 were agents.
So, again, if we go to what Kane says, he won't confirm whether or not they will not protect state agents and killers. He arrested 210 people involved in collusion over 14 years. 207 of them were working for the British state inside illegal organisations carrying out killings. Many of those organisations armed with weapons and intelligence and given safe passage to murder relatives across this island. That's what we're dealing with. That's the reality of what this act is about. This is about closing down truth. It's very stark when you see it in real and life term like that. So the ICRIR has no trust, no support, no confidence from many of the families we are talking to, in wider society as well, people interested in these issues. The landscape prior to the Legacy Act coming in was 450 cases lodged with the Police Ombudsman's Office, which met the grave and exceptional threshold of warranted investigation. Over 500 killings, those complaints constituted. Around 1,100 civil actions and approximately 1,300 unresolved killings related to the conflict sitting in the PSNI's Legacy Investigation Act. Yet inquests that were ongoing, some of them completed, other Section 14 applications to the Attorney General, to reopen older inquests as well. And those processes all involve wrongful convictions, torture, failure to investigate, cover-up, collusion, lethal force, extrajudicial killings, and political assassinations. And despite all the promotion and publicity around the Legacy Act and the ICRIR, despite its resource of £250 million, £250 million, and being operational and up and running, there's only 8 cases at its door. And I think that speaks volume to the lack of trust and confidence in that process that's trying to be foisted upon and forced upon families. So families taking hope and supporting one another, and that's part of why we're here today, and many of the other families that couldn't make today. The Legacy Act and the ICRIR are a direct response to yous in this room and what yous have achieved in inquests with the police ombudsman and battling and going to the streets and going to the courts and telling your stories and getting out there and fighting along with NGOs. That's what this is about. We have hope, and that's the reality is that when they were faced with all of that, they shut it down. The processes such as the police ombudsman and the inquest, albeit slow, they were delivering and they were compliant with human rights law. That it was the starving of the resources to them which was the problem. They had every potential to work. The British stopped them from working, and then they pushed the nuclear button and brought in the Act to close everything down. So the Legacy Act shuts down the processes, and as I said, £250 million is what they have got. So the lack of resources argument's gone. Is gone. It's out of the road now. You've £250 million handed over to do what they want, but we know what they're going to do. It's all semantics. It's all, it's a bit of veneer. When you scratch it, there's nothing to it. So what they're actually doing is they're whitewashing. It's £250 million to whitewash the truth. So we're saying there needs to be urgent legislation or remedial actions and orders to put back in place the package of measures and processes like the Ombudsman's Office, like inquests, and like other processes that are delivering. In the meantime, to do that, and in the long term, to pass legislation that brings about a proper process that's compliant with human rights law and is the Stormont House model that was agreed in 2014. So at Stormont House, it was a negotiated agreement between all the parties. It was a bilateral agreement between both governments. It had a historical investigations unit with full police powers, including powers of subpoena, search and arrest. It had a resourced budget of £150 million. It had a full public consultation and endorsement, albeit with some caveats and concerns. And there was a commitment to implement it within 100 days of the New Decade, New Approach agreement that re-established the Stormont institutions. And the Labour government, the Tory government, what it did was it reneged on it. It binned the Stormont House agreement and it introduced the Legacy Act. And that's essentially just the broad sweep of it. So it's just about the NGOs working together and the campaigning, and you'll see some of the vigils of some of the work that you have been involved in with the NGOs. So I suppose the sense of it is, this is the man that was coming into power, himself and Keir Starmer. Keir Starmer came to Belfast, he went to Queen's University. Law professor Keir McAvoy, that's involved in a lot of this work, put a question to him. If he got into government in Westminster, would he repeal? And he said that they would. And then along comes, when they get into government, we get Hilary Benn, and he says, I will repeal and replace. So we're saying, honour your commitment, honour your pledge. Your Legacy Act, the Tory Legacy Act, has no support. It will not benefit families. You need to stand over you need to stand over the commitment and implement the repeal and replace process. So that's really, folks, where we're kind of at, to give a sense of it. And now I hand over to Paul. Okay.
Thanks a lot, and I want to start off by saying thanks especially to Relatives for Justice, who did the heavy lifting on organising today's conference. It's great to see everybody here in front of us from all over the island. It's really excellent. I was slightly terrified by the number of times that Mark said Paul's going to address this issue and that issue. Am I? Really? But I'll attempt to address some of the issues, in particular the whole notion of what do we now know that we wouldn't know had the Tories had their way. And I think it's really important to keep bringing it back to the Tories and to keep reminding Hilary Benn that he is implementing Tory policies. We need to embarrass them into doing this, because the so-called Independent Commission on Reconciliation Information Retrieval is not independent. It will not lead to reconciliation. I think it would be better to call it the Tory Commission rather than the Independent Commission. And we need to keep reminding them on this. And we need to remind them that had the Tories had their way, we wouldn't have had a bloody Sunday inquiry, for instance. This week, Mike Jackson died, as most of you know. Mike Jackson had memorably told the Bloody Sunday inquiry that although he was in Roswell Street on the day, as a captain, as the second most senior in command, he didn't see anyone being shot at all in Derry on Bloody Sunday. We know that because he was dragged into the witness box during the inquiry and questioned by the barristers for the family. We wouldn't, had the Tories had their way, have had an inquest into the British Army killing of Kathleen Thompson. And had we not had that inquest, we wouldn't have seen barristers for the family drive a coach and horses through the soldier that fired the shots on that day and tear him apart on the witness stand. Had the Tories had their way, we wouldn't have had at least the beginnings of the inquest into the murder of Sean Brown. We've worked with the Brown family since the very beginning, and none of us had any idea of the truth that was eventually going to emerge. Had they had their way, that judge would not have turned round to the Brown family earlier this year and said that there was a number of state agents involved in the murder, but he could only give them a gist of the evidence. There's two full folders regarding that murder that remain redacted, that have never been provided to the family. Why? Why are they holding back this information? Why have they withheld information in terms of what happened in Loughlin Island? And the little, what we do know about Loughlin Island, we know thanks to the police ombudsman. What we know about what happened in Ballymurphy, we know because there was an inquest, because it was finally acknowledged on this island, and to a certain extent in Britain, that a massacre occurred in Belfast 6 months before Bloody Sunday, and that it was a parachute regiment who were responsible for it, and that innocent people were gunned down, and nothing was done about it. And remember, had something been done about Ballymurphy, Bloody Sunday itself would probably never have happened. Had the soldier who shot Kathleen Thompson in November 71 been prosecuted, these other events may not have happened. We know what happened in Sean Graham's and the level of collusion in Sean Graham's and the level of collusion in later police ombudsman's reports into what happened in North Derry and North Antrim because of police ombudsman investigations. They were flawed in certain ways. They didn't go as far as we want them to go. One thing that strikes me, and I know I see John Finucane sitting here in front of us today, is, for instance, every time the Finucane family have said, no, we don't accept that, we demand more. Every time, every single investigation has devolved more information about that murder. Every single time the lid is lifted, we find out more. And that applies, I think, to probably every family in this room. We've seen it in terms of Glenanne, we've seen it in terms of cases that we've worked with. But I want to give one example. We discovered some time ago that there was a closed file in London pertaining to the RUC murder of Paul Witters in Derry during the hunger strike. The file was closed until 2074. And we applied for it, and what happened in response to that was it was closed for a further 10 years as a result. But the family fought and didn't give up and attempted to embarrass the Secretary of State. And eventually they opened half of the file, 50%. And we pushed and pushed and pushed, and eventually they opened all of the file. Now I know there's still a file, a closed file, in respect of Julie Livingston here in Belfast. But we eventually got everything except for, I think, 3-4 pages in terms of what happened to Paul Winters when he was shot by a plastic bullet. And what did we discover? Well, we discovered why they closed the file, and that was that at the time, both the Army and the RUC was aware that when they were firing plastic bullets here and in Derry and elsewhere, that the metal cap that was supposed to become detached when you fire a plastic bullet wasn't becoming detached and was flying through the air at the same time. And Paul had 2 wounds, one from the plastic bullet and one from the metal cap. There was a man killed here in Belfast, Peter Doherty, and the metal cap was embedded in his skull when he was shot dead. But the Ministry of Defence and the RUC hid this information for all those years, and they kept using the same type of weapon, leading to the deaths of other adults and children. So we understood why they kept these files closed. And that's exactly what the Tories would do. That's precisely what their aim is, because they know if the truth comes out, it tells a very, very different story of what actually happened here. And we need to keep pushing and pushing those doors open. I think we find ourselves actually in quite a good place at the moment, and I'll say this for this reason. We're sitting here today with a large number of families. It's October. The British government and the Tory Commission on Reconciliation and Information Retrieval have not succeeded in convincing you that it will work. And it will only succeed if they convince you. It doesn't matter whether Peter Sheridan or Declan Morgan or any of their, it doesn't matter what they do or who they are. The only thing that actually matters, and Hilary Benn has said this, he said, I will give them some time to see if this mechanism will work. So we need to use that time to show them that it doesn't work. That is an absolute, both organisations and other NGOs would say to families, we would recommend you do not engage because you will be re-traumatized. For those individuals, there may be some who say, well, I want to try it. But our plea to you is, you don't need to keep that as a secret. Talk to the 2 organisations so we can at least offer some advice and information background on that. But we would strongly advise you not to engage. So we now find ourselves in October. They are struggling. They're facing massive difficulties. As Mark said, the latest information is that 8 or 9 cases open. One of them was opened because it was a referral from the police in Sussex in England about the bombing on the pub. So they're in a very, very difficult place at this moment in time, and we need to make it more and more difficult for them. I've been at meetings, for instance, with the Brown family. We've said it publicly, so I'm not divulging anything we shouldn't, where the Secretary of State attempted to convince the family of Sean Brown that they should engage with the ICRIR. They told them where to get off very quickly. I know they've done the same with the Finucane family, and eventually they had to set up the inquiry. So I think we're actually in a good place. We need to work together, we need to share information. It's very important that various organisations are coordinating what's happening today, and I look forward to the next session, which is to hear from the family members themselves.
If we can just invite Professor Anna Bryson, who's here representing the Committee on the Administration of Justice and is in Queen's University, and also if we can have Minty and Patricia and Shauna, and I've left off here, Paddy Clark, who I'm about to add to the PowerPoint right now. But I'd saved that, I can only apologise. Please welcome them up to the stage.
Hello, everybody. As Paul said, my name's Anna Bryson, and I'm delighted to have been asked by Relatives for Justice and the Pat Finnegan Centre to chair this session. Basically, this session is an opportunity for the families to share with us, their perspective, the context in which their loved one was murdered, their journey to seek answers, to seek truth and justice. And then if we have time, we'll get around to thinking about where the Legacy Act and the commission that it established has left their families. So first of all, I think as Andrea mentioned, we're all very aware this is not easy for families, so we're extremely grateful to the 4 people either side of me here who have very, very bravely and generously agreed to come forward this morning and to share with us their stories. So without any further ado from me, I'm going to just kind of jump right in. And Minty, if it's okay, I'll introduce, first of all, we have Minty Thompson with us, whose mother was killed in 1971 by the British Army. We also have Paddy Clark, whose brother Joey was killed in March 1975. Patricia Byrne, whose father was shot dead in 1972, and then Sean Quinn, whose brother Dwayne was shot dead back in 1991. So if it's okay, folks, we'll take it in that order. I'm going to ask Minty if it's okay to begin and to share with us, Minty, a little bit about your family story, the context in which your mother was taken from us and the journey that your family has been on.
Good morning, everybody, and thank you for inviting me here today. As you know, my name is Minty Thompson. My mother was shot dead in the backyard of our home in 1971 on the 6th of November, leaving behind 6 children and obviously a husband. In 1972, we were granted obviously an inquest which came out as an open verdict. So 20, 30 years later, we decided to go on the mission to find out the truth and the acknowledgement and possibly justice for our mother. 2013, we were granted a new inquest from the Attorney General. The inquest didn't begin until 2018, but it was adjourned then to track soldiers. 2021, the inquest was returned, and 2022, in June 2022, the coroner ruled that my mother had been shot by, referred to as Soldier D, in circumstances that were not justified and was unjustifiable. But 2023, we were then informed that any potential investigation in relation to her death would not be possible. However, unless with a police investigation. So therefore, 2024, we were back again and we challenged the DPP's decision not to exercise their discretionary power, which would require an investigation. But however, the court ruled us out, and what they said was that the death of our mother would be put among the other 1,000 families that would only remain within that LIB, which meant also that under the new Legacy Act, that it would be shut down. So therefore, what are the only options that we had and would be open to us would be to go to ACRIR. Now, it was made very clear to us that it could be very, very tempting for some families that wanted the prosecution to go down this route. We decided as a family it wasn't for us. And what I'm saying today, and I'm appealing to the families, as much as it is the only option, it would be brilliant, wonderful. What we would want is if we all stood together and said no, because what they will give us will be their justice, their truth, not ours. So I am just again appealing that we ask that no family, if possible, should enter into this situation.
Thanks very much, Minty. I'm going to hand over now to Paddy, if that's all right, Paddy.
No Thank you. I'll just give you some background here, first of all. My name is Paddy Clark. I'm the brother of Joey Clark. Joey was murdered in our family home on the Armour Road by two UVF gunmen in March 1975. He was only 18. Not content with shooting Joey, one of the gunmen then pointed the gun directly at myself and my mother. He pulled the trigger several times, but the gun jammed. One of the gunmen was arrested a month later while under surveillance when he was on his way to shoot a leading loyalist, as there was a feud between the UVF and the UPA at the time. He was subsequently charged with Joey's murder. There was a strong case against him, including being picked out of an identity paraded by my mother and another well-placed witness. However, the charges were withdrawn after the intervention of an officer who would later become a high-ranking member of the Special Branch. This officer deliberately weakened the witness statements before they went to the DPP. The trauma was so great it was hard for my parents to speak about, especially for my father, as the man who killed Joey was the same person that my father had occasionally given a lift to work. For almost 50 years, we've been trying to uncover the truth about Joey's murder. With the support of the Pat Finnegan Centre, we reluctantly engaged with the HET. We received 3 inaccurate and misleading reports. After the HET was closed down, we lodged a complaint with the police ombudsman. And due to the government's starvation of funding for the ombudsman's office, our complaint was not completed before the legacy bill deadline. We have been the victims of British governments, past and present, doing all in their power to hide the truth of their shameful role in this jurisdiction. They have tried to close down legitimate routes by which families get to the truth. This has resulted in the legacy bill, the sole aim of which is to protect soldiers and state agents involved in murder. Families are being re-traumatized in that our democratic rights are being denied. What they're being asked to accept is not what you would call justice or anything like it. I'm no lawyer, but I know that what is being imposed upon us is not morally right or fair. Under the legacy bills, families can no longer have full inquests, proper investigations, or have the right to take civil cases. We're being asked to accept the ICR as the only means by which to find out what happened to our loved ones. I have absolutely no faith in the ICR. It is not independent. It is the British government who decides which cases are looked at, what information is made available. These decisions will be made in secret. Families will not be able to challenge decisions or to have access to legal representation. There will be no independent scrutiny of government activities. Finally, and this is a big factor for our family, the ICR will be headed up by a former PSNI stroke RUC officer who had oversight of Special Branch. It will also include ex-RUC among its investigators. These are the very people who were part of the problem and cover-up of my brother's case. The investigation into Joey's murder was deeply flawed and shambolic. For example, the man charged with Joey's murder was interviewed twice for a total of 19 minutes. The first interview lasted 11 minutes and the second lasted 8 minutes. Not that I'd call an in-depth interrogation. He had hardly time to get his coat off. Also, one of the guns used to kill Joey was from a police forensic lab. The list could go on. We expect the first duty of a government is to protect its citizens. You don't expect them to be implicated in their murder and part of the cover-up. We are now being asked to accept the bill that denies us our rights to justice. What other supposedly free and democratic society would be asked to accept that? As a family, we will not be engaging with the RCI. I believe our greatest strength lies in families standing together to deprive the ICR of legitimacy. Before I finish, I'd just like to thank the human rights lawyers, groups like the Pat Newton Centre and Relatives for Justice for their incredible work in exposing the truth. I have always believed that a win for one family is a win for all families. Thank you.
Thanks very much, Patty. Patricia, if I could hand over to you now, please.
My name is Patricia Burns. My father, Thomas Burns, was a 32-year-old man with a wife and 4 young children, a family man who went to a local bar for a drink one evening in July 1972. He never came home. He was shot and fatally injured by the British Army as he attempted to make his way back home. From that moment, my daddy and our family were ignored and treated like second-class citizens. The army prevented an ambulance from entering the area to help my daddy. He was eventually put into an army vehicle and transported to hospital. He later died from his injuries, and this is when the lies and the injustice began. He was falsely branded a gunman. There was no meaningful investigation into his death, as at that time there was an agreement that any soldier involved in a killing would not be questioned by the RUC. Rather, a less formal internal review by the Royal Military Police took place, which involved the soldier merely giving a statement. They were not questioned as a suspect, rather more like a witness, usually discussed over tea and sandwiches. No one from the government came near my mother to offer condolences or attempt to explain why this awful crime had taken place. In fact, she didn't even get time to breathe. She was now the breadwinner and had to raise 4 young children and look for work. There was a brief inquest where no witnesses were called and pre-written statements from the alleged soldiers were read out. In later years, we discovered that these statements were not only contradictory, but not even written by the people they pertained to be written by. A verdict of misadventure was delivered. This verdict was overturned later by the courts when we were granted a fresh inquest in 2023. Finally, some 51 years after Daddy's killing, these soldiers who had continued to live their lives with no accountability for what they'd done were now facing the prospect of a court hearing. We will get our day in court and we're hopeful of a positive outcome, as other families had attained this through the inquest process. Getting this granted was an enormous relief. We had played the long game, we had followed the law, we had attained this through a court system which finally seemed to be on our side. It had been exhausting and had taken a massive toll on both our physical and mental health, but we did get there. The system was now working for families, but unfortunately for us, it was not working for the British government. Their lies, crimes and cover-ups were being exposed in courts. They could not let this continue, so they changed the law. They invented a new bill without the consent of any victims and rushed it through Parliament, effectively putting an end to our long fought for inquest. Justice was never meant for the likes of us. We were told to forget about it, move on, draw a line, and put our faith into a new body, the ICRIR, which is held by a former RUC officer, and we know we're never going to get anything from it. We were devastated, we were exhausted, we were re-traumatised, and again made to feel worthless. But we weren't beaten. We will not accept this legacy bill or work with the ICRIR. We want nothing less than what we deserve, our inquest, truth and justice for our daddy. We will never give up. Today I plead on behalf of the Burns family and the many other families who are here and elsewhere who are being denied justice, for Hilary Benn to do the right thing, stick to his promise, repeal this so-called Legacy Act and return to the Stormont human rights compliant process that was absolutely delivering truth and justice for families. Give us the peace and answers so that we may finally be able to move forward and live some sort of a normal life for what time we have left. Do not burden another generation with this constant battle to uncover truth and justice. And finally, let our loved ones rest in peace. Thank you, everyone.
Thanks very much, Patricia. Shauna, if I can hand over to you, please.
Okay, so my brother, Dwayne O'Donnell, was killed outside Brown's Bar in Kappa on the 3rd of March 1991. Dwayne was making his way to the pub along with his friends, Malcolm Nugent, John Quinn and Malachy Rafferty. While they approached the pub car park, that's where the loyalist gunmen shot Dwayne, who was 17, Malcolm, who was 20, and John Quinn, who was 22, dead. Malachy Rafferty was the only survivor. It is believed that the gunmen tried to make their way into the pub that night, but on hearing the gunshots, the owner was able to get the door of the pub locked. It's just unimaginable to think how many people could have lost their lives had they accessed the bar. As a result of not being able to enter the bar that night, they then turned their attention to the toilet windows of the bar and they shot dead Tommy Armstrong, who was a 52-year-old man who was drinking in the bar that night. Now, Galway and Kappa, it's a very, very rural area, located 7 miles outside Dungannon. You know, during the conflict, it was believed that there was some of the highest secure and highest surveillance levels in the north of Ireland. And you couldn't get in and out of Galway, you know, without being stopped from one end to the other, you know, with 2 to 3 checkpoints, and that was just the reality of those times. On the actual day of just the week before the shooting, what happened was an army patrol entered the bar in Kappa, and they actually drew a diagram, which was a layout of the pub. And as anybody can imagine, this caused considerable unease at the time among people. But we now know that that was a common feature in this form of attack. So on the actual day of the shooting, in our local GA ground, there was a helicopter that hovered above the football pitch and into early evening. Once again, there was numerous vehicle checkpoints throughout the area on the actual day of the shooting. But all of a sudden, just before the shooting, all military presence disappeared. So basically, the investigation was an absolute whitewash. We had our inquest, we received a ballistics report shortly after the boys were killed in March 1991. This initial ballistics report informed us that the weapons used had been used in a number of other murders. However, we had the inquest in June 1991, but just prior to the inquest, a subsequent ballistics report was sent out to families noting that the weapons used had no other history of usage. We now know this is lies. So again, the whole investigation was a complete whitewash. There was, I don't need to go into it because I'm sure every family in here is the same. So what we did is we engaged with the HET for 7 years. RFJ would have accompanied us to all the meetings, and it was a long, laborious process. My mum was here with us, and Tommy's niece is here with us as well. We would have attended the meetings for those 7 years, but after about year 5, we were continuously promised the report, or a draft report. So every meeting we went to, you know, we were like, well, we'll get the draft report today. So the day that we were promised the draft report, we went to a meeting in the Greenvale Hotel in Cookstown, and there was 2 new employees of the HET. We were like, where's the other 2 that we've been working with here for years? And they said, oh sorry, we are from the white team, and we now know that the white team was those that, where there was evidence of dramatic collusion because of the weapons linkages and all. We had to start from scratch. They wouldn't accept any of the prior information that we had given them, and it's not easy reliving and trying to gather pieces of evidence to bring to those meetings. But we weren't going to let them win, and we did start from scratch, and we did continue. However, the HET closed down. 7 years, and we just were so disheartened, all our families, as you can imagine. But anyway, we ended up having to go to court, and we got the HET report in February 2020, which reported that UDR members operating out of Cookstown Barracks were responsible for my brother, Malcolm, Tommy and John's murders. So we knew then that, okay, here is the report that is stating that the UDR were involved. Whilst we always had our suspicion, we now have it in writing. And we do know that these loyalist gunmen were acting on behalf of the state. You know, these UDR men, there weren't rogue elements of the UDR. This was state-directed sponsored terrorism. So after that, we did try to get an investigation based on the findings of the HET. We were denied that. Last year, we were granted an inquest, and because of the Act, we've been denied that. And just before I do finish off, I'm going to say something. You know, I'm 45, and you know, my mum's early 70s at this stage, right? And I know there's a lot of people that's sitting in this room, and you do get so disheartened. I become disheartened, and I'm probably one of the younger ones. You know, what's it all about? You know, but I have to say, you know, we all need to stand together. We need to stand tall, and we need to let the British government know that we are not and will not accept any more of their dirty tricks, and we have to do this together, and we have to stand tall and do it. I just thought I'd share something with you. My brother Dwayne would have celebrated his 50th birthday last July. So we had a memorial walk that Mummy organised in Galway, and we had Mark up at the event, you know, and it was probably 300-400 people there, you know, and it's about, you know, I'm just going to finish on the Uncle this poem. So I just thought I'd share it with you, now that you know a bit of our background. In the heart of Tyrone is where I am, from a village called Galway I came. It suffered much trauma, sadness and grief, but as a community we overcame. I was the eldest of 5 to Brian and Breach. I was known as a quiet and modest lad. In the shortness of my years, they're the best parents anyone could have had. I played for my local GAA club, and sure maybe I wasn't the best, but I wore that Padraig Pearse badge with pride upon my chest. I could play the Ironton whistle, where I'd know a tune or two. I always loved to read books about Ireland and how those northern troubles grew. It's been over 32 years now since I took my final breath. Just outside Boyd's Bar in Kappa was where I met my faithful death. The bar was full of locals that night, enjoying their few pints of beer, but Tommy didn't survive the attack. He was unaware that death was so near. Sitting in the car that night, I didn't think I was going to die, but I've no regrets in my 17 years, and I've never asked God as to why. I'm joined here with my friends who died with me that night, with Malcolm and John, who had no fear to be part of a great Irish fight. There was a feeling of despair that day as people gathered by the load to see the 4 coffins come together, meeting at Galway Crossroads. Today you're all remembering me as I be turning 50 years old, but I have never went away. I'm in heaven now, wrapped in green, white and gold. My family, friends and comrades that miss me every day. I know how much you loved me, but I promise you I'm okay. And as I bring this poem to an end, I make you one final plea. As the years go by and life continues on, please don't forget to remember me.
Thank you, Shauna. That was beautiful. And thank you for sharing it with us. Thank you all for sharing your stories with us. As we said, it is not easy. I think, Patricia, you talked at times about being devastated, exhausted, re-traumatized, and certainly all of you, you talked about being disheartened at times, Shauna. We're well aware it's not easy, but it's incredibly important for us to hear from you. I think, as we all know, the victims' stories, the victims' perspectives are at the heart of this. The rationale for closing down the road to implement the Stormont House Agreement was the mantra that this is not delivering for families. It's really interesting. We've heard here how the package of measures was delivering for, like, in terms of you, Minty, like with Soldier Deep, if you hadn't had your inquest, you know, would you have been able to get the acknowledgement that your family did get through that process? And I know what I heard from you was a real sense of wanting other families to have that and more. So everybody, I suppose, has been on a different journey. The other thing that I was thinking about, Sean, in your case, when you talked about collusion and the patterns that led up to Dwayne's murder, is around this issue of patterns and themes. And I was wondering if you could say a bit more about that, because I think there is a danger. With the Stormont House Agreement and the ARG, there was, I suppose, a recognition that there was a piece of work that needed to be done around joining up the dots and identifying patterns and themes. And in your case in particular, Sean, I'm just wondering, is there, you know, is that particularly highlighted, the danger of, you know, I suppose closing down the opportunity for that crucial work on looking for patterns and themes across different murders? Maybe would you be okay to say something about that?
What I did say earlier was about the weapons linkages in terms of the HUT report. Then had reported that the weapons used in Kappa were also used in 8 other murders within the Mid Ulster area and also 2 attempted murders. That is the information that we received after the inquest, the first ballistic report from the RUC after they were killed. But then, as I said before, the subsequent one then said there was no history. But in the HUT report, yeah, it did state in terms of the weapons linkages, you know, even moving away from that, but I talked about the diagrams and the layouts of the bars, you know, as a result of HUT reports and, you know, families meeting up, we now know that that was a common feature in terms, you know, there's just so much in terms of that. And yeah, there's just so much that the dots need to be joined up, because in terms of those common features, you know, there should be an overall, you know, way
to try and address all of that.
Yeah.
Absolutely.
Collectively.
Yes. I mean, I think the other thing is it's very interesting to hear that all 4 of you, for, you know, for various reasons, have set yourselves against the ICRIR and seem to have no faith whatsoever that it could deliver for you. What I was hearing was issues particularly around trust, just a sense of just, especially given the experiences that you have had over many, many years of being let down, lied to, and so forth, that obviously then, you know, your threshold for trust is is rightly fairly high, and a sense that you don't trust. I think a couple of you mentioned in particular the appointment of Peter Sheridan as heading up the reviews, and how difficult that is. I mean, is that fair to say, Patricia or Minty, you know, that it is essentially boiling down to this issue of independence you mentioned, and lack of trust in what the ICRIR says that it can and will deliver?
Absolutely. Absolutely. How can, it's just setting somebody from the RUC at the heart of an organisation to investigate themselves. How could that possibly work? How could we have any faith in that?
And do any of you think, in terms of the request for root and branch reform of the Commission, do any of you see any scope for that, or do you think it is so fundamentally flawed that there's no any which way in which it could be? Paddy, maybe I could bring you in on that.
Yeah, I don't think there's any way any of the families here could have any faith in it at all. We've been promised so much, so many times. It's nearly like a mirage in the desert, and say, that's what you're getting there. And as soon as we get anywhere close to it, or close to the truth, it disappears. But then they say, oh no, there's another place over there, we'll go there. So we all head over that direction. But you can only be told the story so many times. And I think now is the time when we should stand up together and say, no, we've had enough. That's it.
Well, I think it is, I mean, it is heartening in many ways, because when we talked about the points at which you've all felt disheartened and so on, at the same time what's coming through, I think, is a very strong sense of the power of standing together here and coming together, you know, to discuss this openly among yourselves, and also to be aware, I suppose, of, in many ways, the power and agency that you have at this moment in time. I suppose for me, when I look at it and think, look, this is supposed to be about reconciliation. We've heard that a number of times, that this commission, that everything it's about is supposed to be about driving forward reconciliation. Certainly my understanding of reconciliation, and a legally compliant understanding of reconciliation, is that it has to have victims at the heart of it, that it has to be driven forward by victims. In that sense, your stories here today could never be more important, could never be more powerful in terms of where we are at in this. So in that sense, I suppose I'm just reiterating my thanks to you for sharing your stories with me. Is there anything else, folks, because I know we've been asked to wrap this up at 5 to 12 and I'm probably liable to go over. Is there anything else that you wanted to share on this panel before we open out into further analysis? Are you happy enough? Well, listen, just thank you all again so much for your bravery and coming forward and sharing your stories with us. We're incredibly grateful. Thank you very, very much.
Of course, this is the point of us being together. The past half hour, 40 minutes, but is exactly the point that we all know that everyone has experienced their own tragedy and trauma, and it is very unique to every single family. But there is so much that people have in common too, and the strength that can be drawn from that is so, so important. So, you know, I know that for the past week, our speakers have been thinking about what they wanted to say. They had beautiful notes for us and wonderful and strong messages for us all. It's so hard to get up in front of a large crowd like this and share such personal experiences, but also what you want. So can we once again just thank Minty, Patricia, Shauna and Paddy for doing that. Our next speaker, we're very, very lucky to have, because I came across him, first of all, through our Twitter page, right? So we've loads and loads of people who say horrible things, but loads and loads of people who really endorse and promote the things that Relatives for Justice, the Pat Finucane Centre, and all of us are trying to say and amplify that. And, you know, to find someone who's in an academic setting who will do that and who will kind of give analysis to the big legal issues that are there in simplified ways has been so helpful in the past a couple of years. And so oh wow, the turnover in PowerPoint has been amazing. And if you're happy now, we'll move over to introduce Colin to talk us through particularly the latest Court of Appeal judgment. Thank you.
Well, good morning, everyone, and I have nothing at all to offer by comparison to what we've heard in the last panel. And talking about the law and going through a judgment seems, well, a poor recompense or a poor way to do justice in dry paragraph after paragraph after paragraph to what we've heard about. But the people who are around us in this room deserve to know what's going on in these judgments more than anyone. And it deserves to sit not with lawyers and academics writing papers about it, but for you to be able to talk about what's happening in these courts matters. And what I'm going to try to tell you is hopefully not going to take too long. I've got about 10 to 15 minutes in the schedule. So don't worry, it is not going to be a full academic lecture on this. But I want you to be able to understand what's going on in terms of the legal tools here. So that when you talk to people about it, you feel you know these judgments and you know what's going on in them. This does not deserve to happen over people's heads. This only works if everyone gets to say, this is what the law is and I understand it in depth. So what I'm going to talk to you about is a tale of two Article 2s. There's Article 2 on the right to life and the European Convention on Human Rights and the state's obligations towards everyone in society, under that whether the state likes these people or not. And then there's secondly Article 2 of the Windsor Framework, which kept certain EU rights protections in place after Brexit. And we only got the Dillon judgment in the Court of Appeal by the confluence, by the coming together of these two strands of law. Now, I've got slides and I'm going to rattle through them very quickly, but I'll make sure they're available to Mark Thompson. And if anyone does want to go into the law in more depth, please ask for them, or I'm sure there'll be many more events between now and this coming before the Supreme Court where we can talk about this in depth. But in terms of Article 2 in the Windsor Framework, what you have is a provision that says we don't go backwards because of Brexit. The 1998 agreement told us that rights are central to society after this agreement, that we're going to build a new place here and we're going to build it all together on the basis of rights because of the awfulness of everything that's gone before. And we didn't get a Northern Ireland Bill of Rights as the 1998 agreement promised in its text. It was talked about and was talked out. So in effect, we were left relying on lots of bits of EU law to provide a basis for rights here, and that was directly connected to the 1998 agreement because we'd never done anything. We'd never been allowed to do anything to replace it. So when Brexit came along, all of those underpinnings of rights were at threat. And one of those sets of rights is rights of victims. When there was the whole debate about the Bill of Rights for this place, it was talked about specifically in terms of giving rights that would recognize victims and their interest in the justice system. And that never happened. But instead, bits of EU law happened that give general rights to people generally involved in prosecution processes, or where there'd been wrong done to them and the state was refusing to do anything about it. Rights that said the state can't just say, we're not going to bother prosecuting and not explain anything at all. And those rights, even though they're not connected to the conflict here, are what's really important to rely on and to think about in the context of this judgment. So, Article 2 is really complex in its terms. It's only because of the series of judgments we've had on it that we can start to understand how it works. It protects specifically some EU directives that are about equality. And they really matter in spheres like employment law. But they also protect a general body of EU law that can be connected to the rights and equality section of the 1998 agreement. And what the UK government promised was that it wasn't going to be able to diminish those rights as a result of Brexit. Now, what was the media debate about Brexit? It was all about trade. All we heard about was trade for years upon years upon years. And why we heard about that was the UK government gave way on this really early in the process, because this was directly connected to the agreement. It was there in terms that people had rights coming from this, and a lot of them were given effect because of EU law. And if the UK government hadn't backed down on this early, well then they were in an almighty fight over Brexit that would have been much more powerful than anything to do with trade rules, because it affects real people in their day-to-day lives, not just businesses. So the UK government was obliged to give in on this, And what we've seen ever since is them trying to say that what they agreed doesn't mean very much in practice. And that's what this fight is all about in terms of the legal substance of these court cases. If you like, there are directives that were protected, but then there are concentric circles leading outwards, an expansive EU law that might apply. But for it to continue to apply after Brexit, you have to connect it to the 1998 agreement. If you can't connect it to the right, safeguards and equality of opportunity section, these protections don't exist. So, where did this come up in the context of the government's arguments in Dillon? Well, remember when the Conservatives were in office, all they talked about was there's not much to see here, the Windsor framework isn't very important, and particularly it only affects trade. This is their attempt to deny its significance. The starting point is the Windsor framework applies only in respect to trade and goods. It doesn't apply on things like the illegal migration bill. They were trying to deny any real legal effect to the protections in Article 2. But the problem was that the courts were already starting to develop their position on a lot of these questions. And what we get in the Dillon judgment is a judgment that works through a test. And at every stage in this test, the UK government fought to say this didn't apply. Is the 1998 agreement even engaged? They fought on this point. But we all know the rights of victims were embedded in that agreement. If you go to the right, safeguards and equality of opportunity section, it says victims have a right to remember and to play a full and active part in society after this agreement. And if people can't get truth, how can they possibly properly remember their loved ones? How can they possibly continue to be fully engaged in society without that? And the court gives a ringing endorsement of the breadth of these human rights grounds and the way the 1998 agreement was supposed to be the foundation of a new society where we base it in rights and we think about the human worth of everyone that lived in our community, irregardless of their political aspirations for it. So the 1998 agreement was engaged, the court said. Secondly, was EU law engaged and diminished? Well, as I said earlier, EU law includes the Victims Directive. And the Victims Directive gives protections against a prosecution being arbitrarily stopped and gives victims the ability to challenge that. Well, if a measure like the Legacy Act comes along and grants blanket immunity, you're taking away that ability of the victim to be engaged in the criminal justice process. And that might seem like a small bit of EU law, a directive hidden away that no one was paying much attention to at the time. But that idea of a diminishment of our rights is exactly what we were told could not happen because of Brexit. That's what connects EU law into what's going on in this case. And then beyond that, there's the other Article 2. Article 2 of the European Convention on Human Rights and the right to life. The state doesn't get to kill people that it does not like. That is human rights law that stretches back to the aftermath of the Second World War. And if you look at this judgment, it goes beyond that as a right. It says that if anyone is killed in suspicious circumstances, there has to be an effective investigation. Because if there's not that, well then what's to stop a state killing with impunity? How can we secure that right to life without this protection? Now, the judgment in the Court of Appeal goes beyond the High Court judgment. The High Court judgment said that taking away all inquests and all civil actions amounted to going too far in terms of an immunity provision, that it couldn't be squared with that idea of an effective investigation and the right to life more broadly. But in the Court of Appeal, there are additional grounds coming into play. Is there, if you like, beyond the focus on immunity, forgive me, it wants me to stay here at all costs. Thanks. Yeah, it talked about the effectiveness of the ICRIR. And lots that we've heard this morning has been about, well, why people don't believe this is very effective. Why people don't simply take it on a matter of trust that this institution has their backs. Because the way this institution has been set up is not like an inquest. It doesn't give people the ability to have legal representation for their interests. And if you, as victims, don't have that protection, how do you know this process is being conducted fairly in your interest? So it's not just that immunity was bad. Of course immunity was bad. But beyond that, the very way the ICRIR functions is to downplay and to minimize the importance of victims in having their say in the process and making that investigation process workable. Go back one slide. Then there are also the security exemptions. Baked in to the legacy legislation is the ability of the Secretary of State to prevent releases of material, even if the ERIR wanted it, on the basis of security concerns. And if that's the case, in the context of a conflict like happened here, what on earth are we taking other than this is just a matter of trust in the UK government, which, let's face it, is one of the actors in this conflict to do the right thing? It is very difficult to find sufficient effectiveness and independence in this process, and the Court of Appeal found that it wasn't there. Now, how has the UK government approached this? Well, if you look at these court judgments and you look at the arguments put by the UK government, there's sort of a shrug of shoulders that starts off in the arguments before the Northern Ireland High Court. The Windsor framework's not very important. Oh, we've thought about human rights concerns. All of this can be minimized. Don't worry about it, was the message to the court. And when they lost in that judgment, they came back with a throw everything but the kitchen sink added approach. We're going to challenge every single element of what's going on in these claims and try to pick holes in it. But the work you've all done, the work groups like Relatives for Justice have done, the work of statutory bodies like the Northern Ireland Human Rights Commission had primed the judiciary here to think about these questions, to be really engaged with the rights issues and the Windsor framework issues. And just throwing the kitchen sink at it didn't work in the Court of Appeal. But that didn't work because of all that work that was done. And because we're here, and the court is in Belfast, and these people making these judgments are in our community and they're live to these arguments. This all now goes to the Supreme Court in London. And London is a lot further in legal terms than a short flight away. These are not judges that are embedded in these arguments. And what they will try to say in this case is that victims got a right to be remembered and a right to take an active part in society in the 1998 agreement. And the UK government will try to argue that doesn't line up with a right to challenge non-prosecution decisions. They will try to pick that very specific hole in what's going on. So the reason I say it really matters for you all to get and understand the law is that the only way this will be decided beyond the UK government's interest in the UK Supreme Court is for there to be lots of focus from the people who are most affected by this to say that a victim's right to engage in this isn't just about some notional effective role in a society 25 years after a conflict ended. But how can that happen? How can anyone do that properly without truth? And the very denial of that is what connects this in to the bits of EU law that are key to what's happening. And the louder that victims groups make that statement, well then the harder a time the UK government is going to have in silencing and sidelining their rights. Thanks very much for your time this morning.
Thank you so much. Now, this is the bit where we're asking something of yourselves. So I'm going to invite Mark, Paul, Colin and Anna to come back up here, if we can. I'm going to ask Priam and Mary Kate to come down to the front to grab microphones. So we have a little bit of a turnover there. So I put Anna on the spot because she's gone, ah. And what I'm going to ask is if Priam's able to do this side, and I think she would probably be taking this microphone, and there is a microphone going to Mary Kate, if that's okay. Hopefully, we will try. I think it's being organised now. I'm going to encourage people to speak and to share their thoughts. First of all, there's no such thing as a stupid question, right? Everything is absolute, because see if I'm thinking about something, I'm going, I don't know, that might sound stupid. I can guarantee 3 people down the road are thinking the same thing. And I'm going to encourage the women in our group as well, because sometimes we find that women think twice before they ask questions too. So I'm going to give it over now. Who wants to chair?
We've only one Reverend Knight, I'm being told, so apologies, but if Mary Kate identifies people on this side. Really, listen, I want to thank everybody for staying with us and for the presentations. This part of the session is the open up. It's about families having their say. So, you know, and if you want to say something or ask a question, and there's no such thing as a stupid question, by the way, put your hand up.
So given, like I live in the Republic of Ireland, yeah, so that colonization uses you're setting these kind of bits of law. If them bits of law are tied into EU law, would it be easier for me to go to the European court as an EU citizen and stop talking about the courts like I've been the last 40 years in Ireland? Is there a vehicle there which I can use as an European citizen? Not living in Northern Ireland.
Okay, shall I field it? Or?
Go ahead.
Okay, in terms of it, what the Court of Appeal does do is talk about these rights in the 1998 agreement, and it says they apply to everyone in the community within the agreement. What the Court of Appeal does is define that as being anyone here in this polity. So there's an effort, even within the Court of Appeal's judgment, to try to limit what that means to, effectively, as it says, residents of Northern Ireland within the judgment. Now, it's very difficult to make that limit stick when people who were residents here or were affected by the conflict here might try to bring a case forward as to why the 1998 agreement applies to them. But there isn't a direct run to the European court. What the Brexit agreement ended up doing was giving our courts here the ability to apply these rights. And so far, in the High Court and the Court of Appeal, they've actually done a pretty good job of making sense of this. The UK government hoped it would be too vague. They hoped it wouldn't really be given legal form that the courts would argue it away. And now that we've heard, and it's horrible to hear at 11 o'clock on a Friday night, that there's been an NIO release saying that this will be appealed to the Supreme Court, they're hoping all of those holes get picked in it again. But there's not a direct run to the European Court of Justice, so the EU law court, with regard to these Brexit rights. it can only be made work through this process. Now, that's maybe putting the darkest spin on this. If the UK Supreme Court completely guts Article 2 of the Windsor Framework, if it takes it and says, rights for people in this place, that was all just a few nice words, it doesn't really mean anything in legal practice. Or it might mean something in legal practice in a vanishingly small number of cases. Well, then there are routes to argue that that in itself, the action of the courts, is a breach of the UK's Brexit commitment. It's not just what the UK government does, it can also be what the courts do. But at that point, it would be for the Irish government to pressure the EU Commission into getting the EU to take an action to say the withdrawal agreement is being breached by this. We're a few steps down the line from that happening, and there isn't really a direct way to short-circuit this process or to get to European Union law courts before. But of course, if the UK government does nothing to fix this, they are not going to get rid of the interstate action launched by the Irish government about human rights law breach. That is going to keep rumbling on. There might be ways to deal with an adverse Supreme Court judgment, but it gets into a realm of politics and arbitration. It doesn't get you into a direct route to court.
Paul just wants to add something.
Yeah, it's somewhat related matter. It's an issue about the Republic that I wanted to flag up earlier that maybe it's a good opportunity to do it now. So there's a number of families that we support who live in the Republic and whose loss of life occurred in the Republic. Justice for the Forgotten Dublin Monaghan, that's part of the Pat Finucane Centre. Those cases are being looked at the moment in Operation Denton. But there's other families in the Republic who filed complaints with the police ombudsman. Like, for instance, Paddy, you filed a complaint. You're waiting for the police ombudsman to begin the process of investigating it. I'm sure that affects other people here in the room. And that has now been stopped. And what most people don't realise is the ICRAR are prohibited by law from looking at any cases in the 26 counties. That means families who had a serious complaint accepted here by statutory body who are going to begin the investigation. That is now stopped, and they've been offered no other opportunity to take that forward. And people aren't aware that that is, in fact, the situation. You'll remember, for instance, Eddie Fullerton. We worked with his family shot dead in Buncrana by the UDA. His case was looked at by the police ombudsman who linked it to other murders. That would no longer be possible.
Hello everyone, my name is Mark Kelly and I am a spokesperson for the United Campaign Against Plastic Bullets. And my sister was Caroline Kelly and she was shot dead in 1981. I just want to start off by saying that myself and my family have absolutely no faith in ICRAR. Obviously with Mario Seaman investigating cases that they should have investigated many years ago, I think it just defeats the purpose of putting it there. It's another way of wasting time and hoping that some more of us will pass away that our families will give up. We all know that's not going to happen. I look around the room and I see a lot of people that started their campaigns when they were much younger and probably felt much stronger. But I think today shows that we weren't much stronger then, we're much stronger now because we're together and we're fighting this together. A lot of respect for the people who told their stories here today because it's not easy. And many times I want to walk away. Many times and just give up and let them win. But they wouldn't be winning even if I walked away because justice belongs to everyone, truth belongs to everyone, and we need to keep that on their mind and keep them informed that we're not going anywhere. I was at a meeting recently in Dublin with the council, and I have to say I never had any real faith in the Irish government. I think I've done a lot for many years. But he spoke to me along Martin, along with other groups and organisations, and to be honest, I wouldn't be a supporter of them, that's the truth. But he listened, and I think he actually heard what we had to say. And that's a fact. I think he really heard what we had to say this time. And I hope that he does what he says he would do and question the British government on violence and the murders that the British Army and the RUC carried out here and covered up and hid. So I hope that's going to happen. I would also hope that they keep the take an interstate case against the British, and they need to keep that going. This ICRIR is not going to anyone or anywhere else for that matter. And they're not going to get anything out of it either. But I would just like to, I would like to thank a lot of the families here for giving me the strength. Well, you know, we're not just being here gives other people around the strength to continue. And as long as we stand together and tell them together, that all we want is truth and justice. We're not looking for hangings. We're looking for truth and justice. Then hopefully someday they'll listen. The Irish government needs to just keep their finger on the pulse, keep supporting us and support us a lot more, especially in public, and let us know that they're there and we can depend on to defend our rights and every person's right for truth and justice.
My name is Christine Buffett. My uncle was shot dead in 1872 by the British Army, then in 1989. My brother was shot dead by the RUC Plastic Collar. He was called after my uncle. I also met the township last month, and I couldn't believe how well he took. He was very well by our stories. We told him of the brutality of our families after the murder of our loved ones. And for Peter Sheridan, he says he was a big question mark on him. I told him no faith in him whatsoever. As in the 1980s, he was head of investigations. In the 80s and 90s were an awful lot of collusion. Those two parts. The RUC investigated my brother's murder. We had no faith then. We told him no faith in him whatsoever. We were not taking part in the bill of shame. We also told them as Irish citizens, we have rights, and they have the right to help us to get truth, justice, and accountability for our loved ones. They said that we're meeting with the British government, and they will be in Belfast and on contact with us to let us know how it went. And we hope and pray what they've said that they will carry out for us. And we will told them that there's no families want anything to do with the bill of shame. So I urge every family not to take anything to do with the bill of shame whatsoever. Thank you.
My name is Joseph Kelly. My father was shot dead in 1972. I also commend every family for being so good to come along. It's very, very difficult. My father was shot on a bus in 1972, coming home from work. My mother she's not agree with having no information at all. She was darkening our door, and not to this very day. I'm darkening our door. Through the years, my father's whole family are dead. I went with Kevin Linders in 2010 to try and get some sort of information set. And you knock down all these doors and close in on them. You keep walking, it drains the energy from you. You know, like Mark was saying there, you have to keep going. Struggle for justice has been an immense strength for our family. But sometimes we get a wee snippet of information. HET came along to our family, and I'm going to tell you the experience. I'll try not to be too long, but you read between the lines of those and you pick out snippets of HET. It's third-rate information. It's third-rate best information. But they're not getting it because they're not allowed to get it. It's third-rate information. I picked between the lines in there, and I got in touch with Kieran McGart. I mean, my father was supposed to be shot in one street. It turned out he was shot in one street. It was supposed to be an out-of-bounds order. This came from Loris, an out-of-bounds order. So my father could be murdered, and there was an out-of-bounds order. And there was nobody in the streets that night. Would you believe? The very 39th Brigade were running about the car because that place was clear, so my father could be slaughtered. because of the murder of Ernest Elliott. And it turned out Ernest Elliott was murdered by the owners, and I had a shot for nothing. Allegations of nothing. So when Kieran McGartle, one we think about the inquest, I'll tell you, he said, when Kieran McGartle applied for the feds in London, 2 pardons, British Army logs came over, and they were as bad as you can get. But my father and the other people, they're as bad as you can get. Not one iota of truth in them. And the very people who investigated my father's murder right at the top were involved in the murder of innocent Catholics in East Belfast, along with Peter and the rest of the period. It's as bad as it gets. Referring to the inquest part, maybe a little knowledge of the inquest. The inquest was horrendous. Sloppy, whatever you want to call it. I want to know the legalities of the inquest. If you know, sometimes when you go to court case, everything has to be perfect and written down, and one letter's wrong, whatever, it's null and void. In the inquest, not to be called, was all written down, it's like something you see on TV. There are no photographs of the bus when they said they were there. You know, when they said, I saw the body of such and such, in the mortuary, they had my oldest brother as well, not my dad. So was the inquest not important?
Thank you. Well, the inquest seems to be just a sham and a careless exercise, perfunctory. And the point being that when families had inquests here, post the devolution of criminal justice and policing as part of the Good Friday Agreement, being an Attorney General, the reopening of inquests and them being held at a different standard, post the Article 2 ruling of May 2001, where the British government was more cognizant of having to do things a bit more better. You had compellability of witnesses, which you didn't have before. You had legal representation and legal aid, which you didn't have before. Previously, it did not rely on lawyers doing it for free. You had the discovery and disclosure of the planning and operational, as opposed to what happened in the moment, in the instant. It was much broader. And then you had access to your own forensic and ballistics people to examine the evidence and interrogate the evidence and interrogate the statements and the witnesses and the people who wrote them. So it was a completely different ballgame now, which is why we are having this commission, this ICRIR as part of the Legacy Act, because they don't want that. They want to retain what you were subjected to back in the day, as opposed to you making an application and reopening your father's inquest and having all of those rights, and for it being conducted openly for the world to see, the family to see, the community to see, the media to see, and it to be adjudicated on and a proper verdict and finding. So that's what they're avoiding. The legislation in the Act, in the ICRIR, and they're, Declan Morgan's telling people I could hold inquests, and as Paul mentioned earlier, he had the audacity to say he could deal with the Brown case, or he could deal with the murder of Pat Finucane, given the amount of evidence there and state involvement, when they couldn't. And he said, I can hold inquests and hold them. And we said, yeah, okay, how do you do that? Where's the disclosure, the discovery, the representation, legal representation of families? How's it going to be done in an open way? Can't be. Well, the legislation won't allow it.
Well, just to finish off here, these people are right here. What you have here is a government involved in the murder of its own citizens, and it wants to investigate itself to the front of the British judge, British hierarchy, British everything. It can't happen. We can't have anybody who's involved in that and in the murder of its own citizens involved in an ICIR. We must have totally independent. And we shouldn't settle for any less, folks. We shouldn't. It's as simple as that. We shouldn't settle for any less. But God knows what we're going through. Horrific times are it. We shouldn't settle for anything that isn't totally independent. Thank you.
Thank you. If anyone wants to speak, please raise your hand. I just want to add a wee thing. It's no coincidence that the day that this legislation was brought in the Queen's speech was the very day the verdict was delivered in the Ballymurphy inquest. That was the day they put this through their parliament and announced it in the Queen's speech. The very day that Siobhan Keegan delivered that groundbreaking verdict. They didn't want any more of that. So, can we get that? Can we get the? Can you let people know just?
Yeah, my My name's Marie Loughlin. I'm one of the, my brother was still at Loughgall, and some of the other family members here as well from Loughgall, we've had so many false starts, so many times we want to give up, and we have, you know, a lot of family members aren't as interested as the ones maybe that's in the room. But will the Labour government be any better? I don't believe they are going to be, because we've already had promises and we put our faith in that, we put our faith in the ATT, we put our faith in different things over the years. So you know, it's not that we want to sort of say, well, something going on, but it's great that groups like yourselves and Loughgall and Justice and everybody else keeps the momentum going, because sometimes you just get burnt out, and I don't believe that the Labour government is going to be much better than the Tories.
No, thanks, Marie. Bernadette? Bernadette?
My name is Bernadette Davlin, not the Bernadette Davlin, by the way. But I'm the older sister of Judy Livingstone. Judy was murdered in 1981, killed an innocent child, killed under Orange Street by a Welsh guard in the British Army. Judy was the youngest of 13 children, burnt out of her home in 1969. She was 3 years of age. Our lives were turned upside down at that stage during the start of troubles. Judy, the night before she died on a hunger strike called Reston, Judy was going to her friend's house. The word just filtered through the streets as she died. Women were out banging their legs to protest the hunger strikes and what the British government were doing. Judy was injured the night of the 12th of May, beautiful summer's night, and subsequently died the next day from her injuries. It was the British Army salad that was passing up the streets to the road and fired in the the crowd. Witnesses went to Woodburn Barracks to make statements and were threatened with prosecution, that they would be prosecuted for rash behaviour. They proceeded with these statements. They very bravely proceeded and gave the statements. We needed 3 inquests to prove that Judy was an innocent child, that the British Army and RUC tried to sully Judy's name and say that she was a writer. Never lifted a stone in her life. Our lives during the Troubles was very much 2 brothers involved in the struggle who were in long cash serving lengthy jail terms during the war. Judy, our house regularly was raided during the night. We were put out of our beds. So Judy was exposed to this horror from a very, very young age. 3 felt of ours. We lost our mother. She was at that time. She put her time in to be with Judy. Sorry for not so long, but just need you to know the horror that the British government has foisted upon us from 1869. And it's still ongoing by trying to bring in this bill, which I hope to God we can sustain and maintain our health to oppose it. 3 inquests that were a complete farce. It subsequently proved that Judy was an innocent child. By the way, I need to say the press were completely complicit in this. The Belfast Telegraph, when Judy died, most of the headlines and a small paragraph given to Judy's death, but most of the content of the article was about Judy's 2 older brothers, much older brothers, as I said, who were serving time, who were murderers. And my mother received hate mail saying basically, we as a family deserve this because of Julie's two older brothers. The British government, the RUC, the British Army should have their heads in shame and stop this process immediately. Very difficult. I know there's so many stories here to tell. And what was sad, there's so many children, mothers, aunts, uncles, brothers and sisters in this room that have never had justice. We did. We've never had justice for Julie's mother. And thanks for listening to me. Hope you love
Good afternoon. My name is Tony Brown. My nephew Paul Withers, age 15, was hit by a plastic bullet on the 15th of April 1981. I was at the recent meeting where a group of us met with Micheál Martin. And I just want to use a quotation from Norman Tebbit, the recent documentary in relation to the Brighton bombing. Mr. Tebbit said, there can be no reconciliation without justice. I would like to change that quotation slightly. There will be no reconciliation until we get justice. And during the meeting with Antonishna, I said to him, justice must not just be done, it must be seen to be done. I am firm in that belief, and I would not have any support for the Tory Legacy Act at all. Finally, I've heard a number of people talking about being disheartened. I first started writing to the Secretary of State, Humphrey Adams, in 1981. We are now on our 25th Secretary of State. I'm not going to give up. Thank you.
How are we doing on time? Okay, so I'm conscious that people have spoken and it's very emotional. I want to thank all of you for it. And we'll have a few more speakers. No, Pat and Tina, and I think there was a hand over here. Okay.
My name is Mother, and my mother Kathleen was one of the...
Will you hold your microphone up, Pat? We can't hear.
My name is Mother, and my mother Kathleen was one of 15 innocents killed in the Marshall massacre. The bomb itself was not meant for the GM bar, the McGurk's bar, it was meant for the GM bar. It was a bar that was frequented by the official IRA, and the story was to be that it was the provisional IRA that blew up the bar where the official IRA were. Therefore, the story would be, and it would cause a lot of trouble between mother's sons, mother's daughters, so on. But because, now this was a car that sat in Henry Street for at least 3/4 of an hour, soldiers had cleared the area before then, and they wouldn't know what to do. But they were able to sit in the car, 3 men, in the middle of a campus area. There was no, the army was, that was it. The HET said the army were in having their tea at the time, and that's why they went to us. So people get planted there, and then because of the bomb itself took them into sweat, they decided to hold on. They were told, or in the shine, weren't to come back until the dark and news. So they drove along and they planted the bomb in Girk's car. Now the story the next day was that it was our own that blew the building up. Our families were tortured. We were labelled bombers. Anybody that went for compensation was pittance, because they said that we were the ones that planted the bomb, brought the bomb in. It was to be removed, it was laid in the place, all the rest of it, you know. So As I say, it's coming up to 53 years in December is the date of our anniversary. 53 years is a long time waiting, asking, pleading, begging, fighting, and shouting for truth and justice that we should all be entitled to. We went down the HET line and well, we ended up in court so many times, we ended up getting one of our the reports washed in its entirety. Now, went down that line and was able to put our faith in it and promised us to do this. My family, when the ICRIR came out, we just looked at it through and said, that's it. We will not trust the British government, we do not trust the British government, and we have no intention of going forward with what they're suggesting.
Okay, thank you.
My name is Tina Barrett. I am the sister of Danny Barrett. Danny was murdered on the 8th of July 1981 by a soldier in the British Army. It was the night after Joe McDonnell had died, and our joint was just a battlefield, and the local disco had been called off. Danny was sitting at the front door with my dad, and I was there too. I was a 7-year-old Jenny. And he was shot dead by the British Army, who in turn said they seen a puff of smoke and they thought he had a rifle, so they shot him. We were lucky, we were very fortunate in saying we got an inquest. Danny was murdered in 81, the inquest was August 82. And during that they gave their truth, which was all complete and utter lies. And I always, if I win an opportunity to repeat this, I always do it. Claire knew as RFJ's beginning of the day, and she always said this, my daddy was Jimmy Barrett, and once he heard the soldier that murdered his son, he said my brother had a gun, and my daddy, small stature, and my uncle Danny Hale, just that people know it's a well-known great footballer, it's just the reason why I'm giving it, was they jumped and they got the soldier in the court in 1982 in Belfast Crown Court, and my dad hit the head of him. And one female put his hand on my daddy's shoulder, and he said, Mr. Barrett, I don't know how you listened to those lies so long. So what's the most important thing to say is, not only was Danny Barrett not a gunman, he wasn't even around. And when his wee body was all in the papers came back, for I have them, I have all the papers. My father's been away as well, but he paid for those, the opportunity, and I do have the info. Our Danny's body, he was as clean as the day he was born. And my daddy died prematurely. We were waiting. Anybody here? My mother didn't hurt. She couldn't. My daddy became 9 when my mummy became her carer. And that's it's the same story. And I'd just like to say, when I heard Carol Ann Kelly and Julia Livingston, I grew up with their names. The way kids get me, I grew up with their names. And when I go to the graveyard, our daddy's back is that sister. You know what I mean? We're all in the same boat. And I certainly won't give up. It's a big part of my life, and I'll always here to fight for truth and justice for Danny Barrett.
It's very short. My name is John the happening of the 1st of the 5th of June 1976, when a group of armed gunmen robbers arrived to the bar. They were unsuccessful in what they had done, but later on they were arrested, taken to court, and inverted commas sentenced. They were all RUC officers, some from the Special Patrol Group, some actually on service on the night. Could I ever believe there would be justice if an ex-RUC man was now going to look at this case? No. So therefore we could object completely to the whole structure of ICRIR. Also, somewhere asked there about British justice or British change. Labour is no different from Tory. We saw that in years ago at Remember time, Secretary of State, who was thought to be there, we met him at the Stormont House. Well, he said he was not a night on the troubles and forget about it was going to happen afterwards. He didn't succeed that time, but the plan was, way back those years, draw a line and no more inquiries. So therefore, in standing together, we succeeded not let him agree to this line over the sand. He now talks about what should be done, which is different. It's the same with the present Secretary of State. He wants to go with the matter he promised that the legacy bill would be thrown out, lock, stock, and barrel. The security forces have got to now minister some time because he knows he's under pressure. So all I'm saying now is we should every way disagree with any possibility of any small or ever come to fruition. Thank you.
I just say, I want to thank everybody that's made a contribution. I'm conscious of time in there. Like PFC, Paul's here, I'm here, all our staff are here, Colin's here, Anna's here, a number of people. If you know, engages and talk to us, because I'm just conscious of the time and moving things along into kind of end. There's one thing I just want to do before we break. I want to kind of put just a bit of emotion, and we'll come back to this, but I want to put a motion to this conference that we have no confidence in the ICRIR. We want the British government, the current British government, to honour its pledge to repeal and replace the Legacy Act and to get back to the all-party bilateral agreement of Stormont House. And we want the process of Stormont House Plus. We want remedial orders and legislation to put back in place the package of measures, which are inquests, investigations at the Ombudsman's Office, and processes to be resourced by the £250 million budget currently given to Declan Morgan and his team sitting doing nothing in Belfast currently. We want that money to be redeployed and used. So maybe if we could have a show of hands of that, how people feel, do we pass that? Do we pass this message loud and clear? Goramina Moegav. Goramina. And again, just thank our panelists, the families that spoke today, the people that spoke so emotionally and movingly from the floor, other people that have spoken to us privately throughout the morning. We're here to continue that. There is support. You always know you can contact us for emotional support as well and engage us. We know these are difficult issues that you carry. But once again, thank you, and thank to the Falls Council staff, this wonderful centre, Ianod Aileen Hall, a great community leader in this community who fought for justice for decades and who prematurely passed away. So we remember all victims as well at this conference, and justice for all, justice for everyone. Thank you.